Thanks so much for being with us. Breaking news at this hour this afternoon. Closing arguments in the trial of Kyle Rittenhouse are underway. He is the teenager charged with shooting 3 people, killing 2 in Kenosha during the riots that followed the police shooting of Jacob Blake. We have team coverage for you this afternoon. We'll be checking in later with our legal expert, Patrick Cafferty, local attorney. But we begin with our Andrea Albers, who has been closely following the trial. And we just took a break, right, Andrea?
That's right, Vince. Closing arguments first began around 40 minutes ago. The prosecution told the judge their presentation will take about 2 hours. Right now, they've paused for lunch. We are entering the final phases of this trial, and so this morning the judge read lengthy instructions to the jury, at least 30 pages worth of definitions and directions on how to apply the law to this case during deliberation. But now that applies to 5 charges instead of 6. Before the jury was brought into the courtroom this morning, Judge Bruce Schroeder dismissed the sole misdemeanor charge against Kyle Rittenhouse.
6 is no longer part of your consideration. That was the firearm charge.
The prosecution told Judge Schroeder that they would not dispute that the size of the gun Rittenhouse had fell within an exception in state law for 16 and 17-year-olds in possession of certain sized rifles. However, as closing arguments get underway, the prosecution has said it will argue it's unlawful to point a weapon at someone. 5 felony charges remain, the most serious, first-degree intentional homicide in the death of Anthony Huber. The judge ruled the jury will be allowed to consider lesser charges for that count and for count 5, which is the attempted first-degree intentional homicide of Gage Grosskreutz. The jury cannot consider lesser charges for the death of Joseph Rosenbaum or on 2 counts of recklessly endangering safety. In reading the instructions to the jury, the judge reminded the group that they must make their decisions based solely on the evidence, saying, quote, "You are the sole judges of the facts, and I am the judge of the law only." On each count, the jury has been told to consider self-defense.
So, folks, what I was talking about with the cases that you have multiple possible verdicts submitted to you for consideration, when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses.
Now, the jury will also get written instructions. There are 18 jurors right now. 12 will be selected at random to enter deliberation and decide this case. Judge Schroeder has still not ruled on a motion for mistrial from the defense. The judge acknowledged that this morning and said he would rule on it at some point. Reporting live in the newsroom, Andrea Albers, TMJ4 News.
Andrea, thanks for getting us caught up. A lot still happened this morning. We are joined by local attorney and legal analyst Patrick Cafferty, who's been with us through the length of the trial. Patrick, good to see you this afternoon. To the point that we who are casual observers of this trial, the judge this morning sided with the defense and dropped the gun charge against Kyle Rittenhouse. That's the one charge that kind of seemed like a slam dunk to most people until you get into the legal definitions and interpretations. So how is it the judge came to that conclusion?
So different judges have interpreted this law differently. This judge came down on the side of saying that basically it prohibited underage persons from possessing certain types of firearms that basically have a shorter barrel. I think the bigger issue, though, is the fact that this is dismissed injures the government's case. That combined with the fact that the curfew violation has now been dismissed undermines the government's case in that their narrative from the beginning has been this kid didn't belong there because he was in violation of the curfew. He didn't have the legal right to possess this firearm, and then it was supposed to roll from there. Now that those charges are gone, they can't argue, hey, start there, find him guilty of those 2 charges, and move on to the bigger charges. They can still make the argument that he shouldn't have been there. There was a curfew in place. They can still make the argument it's not a sensible thing for a 17-year-old to be there with a firearm, but it would have been a better argument if they could have asked the jury to find him guilty of those two charges and then move on to the bigger charges.
We're talking with local attorney and legal analyst Patrick Cafferty. Patrick, so we're now into the early part of the closing arguments, as we call them. The prosecution has just begun that. They've taken a break for lunch, and we'll pick up after that. As we look at these arguments, I think what's so interesting is we've talked about many of the facts of the case not really being in dispute. There's so much video evidence that the jurors have seen, and a lot of it is just out there. It is what it is. I think for that reason, maybe these closing arguments are so important for the jurors to see how are these two sides framing what we agree happened.
You're absolutely correct. What we're going to see from the state here is they have elevated the sanctity of human life. They've used, language to make it clear that everyone agrees that life is valuable. And they're going to bring home the somberness of this. There are human beings who have lost their lives. There's a human being who was seriously injured as a result of this. And I think so far the state has done a good job of that. What you're ultimately going to have to see them move into, though, is justifying their position by convincing the jury that even if Rittenhouse believed himself that he had to employ self-defense, it wasn't a reasonable belief. A reasonable person in his position would have believed there were alternatives to the level of force that he used.
I want you to put on your defense attorney cap for a moment and tell us what's happening now on that side of things as the prosecutor is giving his summation. Are you sitting there looking for each thing that he says, Patrick, in his summation, and then you're going to go pick that apart piece by piece, or do you have something that's fully prepared and ready to go when it's your turn?
So generally speaking, in a case like this, especially when there's an affirmative defense that's being put forth, here, self-defense, the defense lawyers have their argument mapped out. They're not going to simply get up and say, hey, let me talk to you about what the DA said. I want to counter that. They are going to forcefully put forth their claim that he acted in self-defense. They may tweak the argument somewhat to counter some of the things that the government is putting forth in their argument. But generally speaking, they've got a real good idea as to what the DA is going to say, what the evidence is, and they are going to forcefully make their own argument. Ultimately, the DA gets to come back and counter argue after the defense has put forth their argument. The defense doesn't get a second kick at the cat. They get this one argument to make, so they're going to put everything into it that they can.
How do you think this plays out then late this afternoon? I assume based on the judge's timeline that you will have both sides and then that rebuttal, as you indicated, wrapping up maybe late in the afternoon, early evening. Judge Schroeder's kind of interesting. I wonder if I could see him go either way. Send the jury home and say, have a good night's sleep. We'll start again in the morning. Or let's order dinner and see if you guys get things going this evening.
Yeah, it's unclear. He took a vote among the jurors as to what it is they wanted to do. It sounds like there was a difference in opinion, and some of that may depend on exactly what time they finish this afternoon. But it might be a good idea for him to send them home and let them think about this, come back fresh, and start in the morning debating with one another what the right thing to do is.
Patrick Cafferty, local defense attorney and our legal analyst through these last couple of weeks. Thanks again, Patrick. We'll speak with you in the morning, and I know you're featured this evening once again as well. Certainly appreciate your perspective.
You bet, Vince. Thank you.
All right, meanwhile, we do know that National Guard members are on standby. They are ready to deploy to Kenosha if there is unrest following the verdict. Governor Tony Evers signed an order authorizing approximately 500 National Guard troops to assist authorities in Kenosha following the trial of Kyle Rittenhouse. Officials say they will stage outside Kenosha in standby mode, ready to respond if requested by law enforcement. You can watch the trial live on Court TV on our channel Over the Air 4.3. Our Stephanie Haynes is in court once again today. Will bring us the latest updates starting today on our news at 5 o'clock.